Question 916. Public buildings like churches and libraries are generally appraised using which method? A. Cost approach. B. Sales comparison approach. C. Income approach. D. Market approach. Correct answer is a cost approach. Sales comparison approach method relies on recent sales of similar properties. Income approach method is used to value income-generating properties, such as rental properties or commercial buildings. Market approach is the term often used interchangeably with the sales comparison approach. The cost approach considers just what the land, without structures, would cost. Adds the cost of actual construction, then deducts depreciation. The cost approach is most often used for public buildings, because of the usual lack of recently sold comparable properties in the local market. Public buildings earn no income, so the income approach cannot be used either. Question 917. An interested buyer makes an offer to a broker of $900,000 on a property that is listed for $1 million. The seller responds with a counteroffer of $950,000 communicated by the broker to the prospective buyer, who makes no response. A week later, the seller instructs the listing broker that he is accepting the buyer's first offer of $900,000. At this point, the parties have A. No agreement. B. A valid agreement. C. An agreement that can be modified as to the asking price by the buyer. D. A conditional agreement with a fee simple defeasible. Correct answer is A. No agreement. This scenario involves the fundamental principles of offer and acceptance in contract law. The buyer made an offer of $900,000. When the seller responded with a counteroffer of $950,000, this action legally rejected the buyer's original $900,000 offer. A counteroffer simultaneously rejects the original offer and creates a new offer. The buyer made no response to the seller's $950,000 counteroffer, meaning it was not accepted and eventually terminated. A week later, when the seller tried to accept the buyer's original offer of $900,000, that offer no longer existed. It had been terminated by the seller's own counteroffer. Since the original offer was terminated by the counteroffer, and the counteroffer was never accepted, there is no binding contract. Therefore, at this point, the parties have A. No agreement. Question 918. What is a tender? A. An unconditional offer of performance of one party's contractual obligations. B. An offer of money from one broker in order to obtain a listing from an owner. C. A request by one party to shorten the escrow period and complete the transaction. D. None of the above. Correct answer is A. An unconditional offer of performance of one party's contractual obligations. A tender is a formal offer to perform a contractual obligation. It signifies that one party to a contract is ready, willing, and able to fulfill their side of the agreement, typically involving the offer of money or delivery of goods or services. If the other party refuses this performance without a valid legal reason, the party offering it has fulfilled their duty. This means they might be excused from any further obligations under the contract. They could also have grounds to sue for breach of contract. For example, in a real estate transaction, a buyer's tender of payment would be the offer to pay the agreed-upon purchase price to the seller. Question 919. A promise made by a third person to a creditor that the third person will be responsible for a creditor's debt is called A. Third-party promise. B. Contract of suretyship. C. Vicarious liability. D. Debtor-to-creditor transference. Correct answer is B. Contract of suretyship. When a third person promises a creditor that they will be responsible for a debtor's debt, this legal arrangement is called a contract of suretyship. In a suretyship, the third person, the surety, becomes primarily liable for the debt alongside the original debtor. This means the creditor can pursue payment directly from the surety without first attempting to collect from the original debtor. This differs from a guarantee, where the guarantor's liability is typically secondary, meaning the creditor must first attempt to collect from the principal debtor. Question 920. The performance of a contractual duty, as compelled by a court in cases where damages would not be an adequate remedy, is called A. Equitable action. B. Recapture clause. C. Escrow payment. D. Specific performance. Correct answer is D. Specific performance. Specific performance is an equitable remedy often sought in real estate transactions because each piece of property is considered unique. If a seller breaks a contract to sell land, the buyer can request specific performance from a court. This legal action forces the seller to complete the sale. It's often sought because no monetary compensation can truly replace a unique parcel of land. Question 921. During the escrow period, a buyer and seller have a dispute and their property transaction fails to close. Both parties demand the earnest money from the broker acting as the escrow holder, who should A. Turn the earnest money over to the Bureau of Real Estate. B. Return the earnest money to the seller. C. Retain the earnest money during a cooling-off period. D. File an interpleader action. Correct answer is D. File an interpleader action. When a dispute arises between the buyer and seller regarding the earnest money, the escrow holder is in a difficult position. To protect themselves from liability, the best course of action is to file an interpleader action. This is a legal procedure where the escrow holder can ask the court to determine who is entitled to the funds. The court will then review the terms of the purchase agreement, any relevant laws, and any evidence presented by both parties to make a decision. This approach ensures that the escrow holder is not held responsible for the dispute and allows the court to resolve the matter fairly. Question 922. Listing broker Linus is requested by buyer Bruce to hold a deposit check for 60 days. The broker's best response would be to A. Inform the buyer that the check can only be held for a week. B. Decline the buyer's request. C. Accept the deposit and promise to hold the check, without informing the buyer. D. Accept the check, but inform the buyer that the seller will make the choice on whether to grant the requested hold. Correct answer is D. Accept the check, but inform the buyer that the seller will make the choice on whether to grant the requested hold. Brokers generally don't have the authority to unilaterally hold a buyer's deposit for an extended period. The decision to hold the deposit typically rests with the seller. It's crucial to have a clear understanding with the seller regarding the holding of the deposit. The broker should discuss the buyer's request with the seller and obtain their consent before accepting the deposit with the 60-day hold. By informing the buyer that the seller will ultimately decide on the hold period, the broker maintains transparency and avoids potential misunderstandings. Question 923. Which of these instruments must be recorded in the county recorder's office to be valid? A. Easement in gross. B. Commercial rental lease. C. Declaration of homestead. D. Land contract. Correct answer is C. Declaration of homestead. Although some states require that land contracts be recorded for validity, California does not. Easements and leases also do not need recording, but a declaration of homestead does. Declaration of homestead is recorded to protect a homeowner's primary residence from certain creditors, while other documents may be recorded for various reasons. The declaration of homestead is specifically designed to be recorded to provide legal protection to the homeowner. Key takeaway: recording documents with the county recorder's office provides constructive notice to the world about the rights and interests related to a property. Question 924. A contract obtained by a party committing a fraudulent act is A. Modifiable, B. Valid, C. Automatically cancelled, D. Voidable. Correct answer is D. Voidable. In the case of fraud, the innocent party has the right to choose to either 1. Void the contract. This means they can cancel the contract and be released from their obligations under it. 2. Ratify the contract. This means they can choose to uphold the contract despite the fraud. While fraud can lead to the cancellation of a contract, it's not automatically cancelled. The injured party has the right to choose whether to void the contract or not. When a contract is obtained through fraudulent means, the innocent party has the right to void the contract. This means they can choose to cancel the agreement and be released from their obligations under it. Question 925. A broker holding a non-exclusive listing for a sold property wishing to demonstrate she is entitled to a commission must show that she A. Held a broker's license at the time of the sale, B. Found a ready, willing and able purchaser for the property, C. Was the procuring cause of the sale, D. All of the above. Correct answer is D. All of the above. To be entitled to a commission on a non-exclusive listing, a broker must demonstrate the following. 1. The broker must be a licensed real estate professional at the time the sale is finalized. 2. The broker must have presented a qualified buyer who was ready, willing, and able to purchase the property on the seller's terms. 3. The broker's actions directly led to the successful sale of the property. This can be demonstrated through various means, such as showing the property to the buyer, negotiating with the buyer, or providing information that ultimately led to the sale. If the broker can demonstrate all these factors, they can claim their commission even though they may not have the exclusive right to sell the property.